Welcome to this explainer, where we're diving into Case Law No. 02-2016/AL. We've got a truly fascinating legal dispute to unpack today. We're talking about a massive sum of money, a family completely torn apart, and the very real, very messy risks of cross-border proxy investments. So if you've ever wondered how the law actually handles situations where one person pays for a piece of property, but another person puts their name on the deed, well, you're definitely going to want to pay close attention to the story we're exploring today.
Okay, here is our roadmap for today. We're going to cover 1, the background of the dispute, 2, the two sides, 3, the legal journey, 4, the Supreme Court ruling, and finally 5, the court precedent. Let's get right into it.
Section 1, background of the dispute. To really understand why this precedent is absolutely vital, especially for overseas Vietnamese investing back home, we first have to look at the explosive event that triggered this whole lawsuit in the first place.
The central conflict of our explainer revolves around one massive payout, 1.26 billion Vietnamese dong. This cash was generated from the sale of over 7,500 square meters of agricultural land down in Sóc Trăng province. Now keep in mind, back in 2004 when the sale actually happened, 1.26 billion VND was a staggering amount of wealth. And, when there's that kind of money sitting on the table, family ties can get tested in the worst possible ways. So how did this all build up? It started way back in 1993. Miss Thong, who was an overseas Vietnamese woman living in the Netherlands, came back to Vietnam to visit her family. She wanted to buy some land so her siblings could farm it and, help support their parents. The land was bought for roughly 22 pounds of gold. Now, because she lived abroad, she let her brother, Mr. Tom, stand as the proxy on the deed, which he officially registered the very next year in 1994. But the fuse on this whole thing wasn't actually lit until 11 years later. In 2004, Mr. Tom quietly turned around and sold the land to a company for that 1.26 billion VND, completely without telling his sister. So by 2005, a furious Miss Thung filed a lawsuit to get her money back. Section 2, the two sides. By the time the lawsuit hit the courts in 2005, the brother and sister were presenting completely contradictory stories about who actually owned that 1.26 billion VND. It was a total fracture of the family narrative. We have a classic he said, she said scenario here. On one side, Thang claims she funded the purchase entirely with her own gold as an overseas investor, and she just used her brother as a proxy to handle the local paperwork. But on the other side, Tom claims he is the legitimate sole owner. He says he and his wife bought the land with their own money, they have the legal 1994 deed to prove it, and he even went so far as to outright accuse his sister of forging the original 1993 transfer document. So how did the evidence actually stack up in court? Well, Tom actually had a point about the paperwork. Police forensics showed that he did not sign the original 1993 transfer document that Ton brought in. But, and this is a huge but, literally everyone else involved in the transaction testified against Tom. The original sellers confirmed Thon directly negotiated with them and handed them the gold. And even more powerfully, their own parents and the rest of the siblings testified that Thon was absolutely the one who funded the purchase, and Tom was just putting his name on the deed for her. Section 3, the legal journey. Armed with this super conflicting evidence, a legally registered deed in the brother's name on one hand versus overwhelming family witness testimony supporting the sister on the other, the lower courts had an incredibly tough time figuring out what to do with the cash. And this led to a remarkably chaotic legal journey. Just think about how wildly these legal interpretations swung. The first instance court in 2006 looked at this whole mess and essentially split the baby in half, awarding Tang 630 million VND, which is exactly 50% of the sale. Neither side was happy with that, right? So they appealed. Then the appellate court stepped in later that same year and made a completely different, frankly drastic decision that pretty much shocked everyone involved. Let's break down the math the appellate court used, because it's wild. They decided that since Tanj was an overseas resident, she wasn't legally allowed to own the land anyway. So they returned Tanj's original investment, the equivalent to that 1993 gold, which was about 27 million VND. But what about the massive profit, that remaining 1.2 billion VND? While the appellate court ordered it to be confiscated and dumped right into the state budget. So suddenly, both the brother and the sister ended up losing the vast majority of the wealth. Section 4, the Supreme Court ruling.
Unsurprisingly, neither side was just going to sit back and watch the state walk away with their family's wealth. The Chief Justice actually protested the decision, which led to the Supreme Court stepping in for a final review in 2010 to clean up this entire mess.
The crucial point here is that the Supreme Court found the lower courts completely messed up the application of the law. First, based on all that witness testimony, they confirmed Tong clearly bought the land, and Tam was just a proxy. Second, and this is key, the state had absolutely no legal right under the 2005 Civil Code to confiscate the profit. The lower courts had misclassified the entire case. They treated it as an illegal attempt to reclaim property rather than what it actually was, a dispute over who owned the monetary profits of an investment. So the Supreme Court completely invalidated those previous rulings. To actually fix this, the Supreme Court created an incredibly elegant formula. They ruled that Tong gets her initial original investment back right off the top. But then, what about the profit? The court recognized that Tom wasn't just a name on a piece of paper. Think about it. For over a decade, he actively managed the land, protected it, and handled all the administration that ultimately allowed it to be sold for such a huge profit. Because of that, the remaining profit is split equally between the investor and the proxy.
Section 5, the core precedent. This logical mathematical solution wasn't just a win for this one specific family. The Supreme Court's reasoning was so balanced and effective that it was officially adopted as case law in 2016. It became the gold standard for courts across the entire country. This case officially and legally defined the concept of preservation effort. It established that domestic proxies who manage property on behalf of someone else, they aren't just doing a free favor. They are providing a real, tangible service. It ensures that proxies are fairly compensated for their vital role in maintaining, protecting, and ultimately increasing the value of the investment over time. The official text of the precedent states this brilliantly. It openly acknowledges that it is incredibly hard to quantify exactly how much effort a proxy puts in over 10 years. I mean, how do you measure that? So the court created a default rule. If you cannot perfectly calculate the proxy's exact effort, you just assume the funder and the proxy have equal effort, meaning you split the profits 50-50. This creates such a clear, predictable baseline for resolving these incredibly messy family disputes.
As we wrap up this explainer, I really want you to consider this final thought. Knowing that the law assumes a 50-50 profit split for proxy management if a dispute arises, how is this going to change the future of cross-border family investments? If you are sending money home to buy property in someone else's name, shouldn't you draft a clear contract right up front defining exactly what their preservation effort is actually worth? Because if you don't, as Case Law 02/2016 clearly shows us, the courts have already decided that the proxy gets half. Thanks for joining me on this explainer, and keep learning.